As I'm recording this, it is the evening of February 13th, and already during the 2023 regular session of the General Assembly, several bills have been filed in the House and the Senate that deal in some way with the overall issue of rights in public education, whether they are students' rights, parents' rights, or staff and educators' rights. There are several bills in the House and primarily one bill in the Senate. That bill has already had a hearing at this point and been passed out of the Senate Education Committee. We wanted to talk a little bit about that since we have gotten a lot of questions at KSBA from our members and superintendents and other folks in school districts as to what that bill would actually do and not do. Again, several other bills have been filed on this. So far, however, Senate Bill 150 is the only one that has actually begun moving through the process with the committee hearing. It also could still go completely through the process and be amended numerous times. So we are going to be discussing this evening the original filed version of that bill. In all likelihood, by the time that you watch this video, there may have been amendments filed to that bill that may or may not have passed. As you can see on your screen now, this is Senate Bill 150. It is fairly short. It is about 5 pages long, and it is only involving 2 sections of Kentucky state statute. Some of the other bills on this topic, especially several bills in the House, are much more lengthy. Some of them are almost 30 pages long, with several sections of statute being amended or created. There is a lot of confusion among the bills and also confusion even within Senate Bill 150 because a lot of folks will read a summary of the bill or an article about the bill and sometimes feel a little bit hesitant to actually try to find it on the LRC website and read through it as to what it actually does. But that is what we wanted to do tonight, primarily for our members. Before I begin, I want to make sure you understand that as KSBA has not taken a stance either way on this or any of these bills at this point. And also, we are just summarizing the bill as we read it. None of this should be construed as any legal advice provided to school board members, school boards, or districts on behalf of KSBA. As you can see, the title of Senate Bill 150 is an act relating to rights in public schools. There are only 2 sections of the bill. The first section begins on the top of your screen, creating an all-new statute in Chapter 158. It would define a couple of terms: external healthcare provider. The term health services, as you can see, is already defined in state law and has been for many years, dealing with all sorts of physical and mental health services that are provided in or through public schools. That term is not new. Mental health services is services provided by a school-based mental health services provider. That term and that group of licensed professionals is already defined in state law from a couple of years ago in the State School Safety and Resiliency Act. And of course, a definition for parents specific to this section. You can see at the top of your screen, subsection 2 begins by saying that upon a student's enrollment and at the beginning of each school year, the district shall provide a notification to the student's parents listing each of the health services and mental health services available at the student's school and of the parent's right to withhold consent or decline any specific service. A parent's consent to a health service or mental health service shall not waive the parent's right to access the student's educational or health records held by the district or notifications mentioned elsewhere in the bill. This simply gets down to notification to parents of all of the health and mental health services provided in the schools, requests for their consent for their student to access any of those services. That is not too unlike what we already currently see under local board policies, especially with the sort of at least the annual notice at the beginning of the year. You see there in subsection 3, it states that except as provided in subsection 5 of this section further down the page, as part of a school district's effort to provide a safe and supportive learning environment for students, a school shall notify a student's parents if either of these 2 things occur. 1, if the school changes the health services or mental health services provided to the student, that is, during the year, if it changes based on what the notice already was that we read earlier, or if school personnel make a referral for the student to receive a school's health services or mental health services, or a referral to an external healthcare provider outside the school district. Again, this is just notification to the parents and guardians of a student. Then in subsection 4, it states that school districts and district personnel shall respect the rights of parents to make decisions regarding the upbringing and control of the student through procedures encouraging students to discuss mental or physical health or life issues with their parents, or through facilitating the discussion with their parents. This really gets back to something that was mentioned in the committee testimony last week on this bill, dealing with several Supreme Court decisions at our state Supreme Court interpreting our state constitution, as well as the United States Supreme Court interpreting the American U.S. Constitution. There have been many interpretations and many opinions over decades at this point, laying out the fundamental rights of parents to direct the upbringing and various decisions regarding their children. Several of these important cases were cited by name in the committee testimony, and this really gets back to sort of tying that in state statute. You can see now in subsection 5, this fills up all of your screen. This states that the Kentucky Board of Education, that is the State Board of Education in Frankfort, or the Kentucky Department of Education, shall not require or recommend that a local school district keep any student information confidential from a student's parents. A district or school shall not adopt policies or procedures with the intent of keeping any student information confidential from parents. This also ties back in some ways to two primary interests. One is already existing state and federal privacy rights dealing specifically with educational records dealing with students in our public schools. At the federal level, that is, of course, called FERPA. And at the state level, we have a similar law enshrined in our state statutes that we usually call KFERPA or Kentucky FERPA. We could spend an entire webinar discussing the exact details and requirements and rules that are contained in those state and federal laws. Generally, it boils down to the fact that most, if not all, educational records maintained about a specific student by a school district are subject to inspection by their parents. And also that at least once a year, the district shall provide notice to parents about FERPA, the law, what it says, and their right to inspect those records. Then it says that the Board of Education or the department shall not require or recommend policies or procedures for the use of pronouns that do not conform to a student's biological sex as indicated on that student's original unedited birth certificate issued at the time of birth pursuant to a state statute. There again, this specific paragraph does not deal with anything at the local level. This is saying that the state board and Department of Ed shall not require or recommend local policies really regarding the use of pronouns that do not conform to a student's biological sex. Now, we're going to get to a couple of things on that issue, as well as the FERPA rights that many people have asked about in just a moment. Now, at paragraph C at the top of your screen, it goes further to the local level by saying that a local school district shall not require school personnel or students to use pronouns for other students that do not conform to their biological sex as referenced above. This, what you see on your screen now, has probably caused the most questions that have come into our office since last week. This paragraph would do just as it says. A local school district could not require staff or other students to refer to another student under use of pronouns that do not conform to their biological sex at birth. This does not directly impact any state, local, or federal harassment or discrimination provisions in law or constitution. This does not require or control anything about various accommodations that can be provided in terms of referring to a student by their legal name or moving to a student to one class or another. This really ties back to, again, an issue of constitutional law dealing with the First Amendment and free speech. As I said earlier about parents' rights in general, there have been many court interpretations in many cases over the years in the state Supreme Court and the U.S. Supreme Court that have really outlined the nature of, in the school context, a student's First Amendment's right of free speech, and also the public employee rights of free speech in the workplace, including specifically school district employees in the educational setting. Many people watching this may be familiar. One of the first major court cases on this issue dealt with students wearing armbands to school to protest American involvement in the Vietnam War. There have been many cases building upon that in a long, decades-long now line of cases interpreting what districts can allow staff and students to say, to express themselves, as well as what you can require either students or staff to say or not say, or to say in certain ways. That is a very, frankly, complex area of law. Only a couple of years ago, another opinion from the U.S. Supreme Court dealt with this issue in terms of what students could say on social media outside of school hours. This provision, if this passes into law, we believe would largely align with what the current state of the law is, at least that is controlling and binding in Kentucky. But that also is something that is being litigated in federal courts even as we speak. Then an important provision is at the top of your screen now. This has gotten many questions. I will just simply read it through. Nothing in this subsection, which means nothing that we just discussed about First Amendment rights, free speech, policies involving pronouns, and keeping information confidential. This says nothing in this subsection shall prohibit a district or personnel from withholding information from a parent if a reasonably prudent person would believe, based on previous conduct and history, that the disclosure would result in the child becoming a dependent child, which largely means abandoned, or abused or neglected as defined in state law. The fact that district personnel withhold information from a parent under this provision shall not in itself constitute evidence of failure to report child abuse, neglect, or dependency. Of course, as everyone knows, essentially every adult in our public schools in Kentucky is a mandated reporter of suspected child abuse, neglect, and abandonment by state law. What this provision is saying is that even as the bill is in some ways ensuring and requiring that parents have access to educational records and information, that of course districts would not be required to share information, just as it says, if a reasonably prudent person would believe that doing so could subject the child to neglect, abuse, or abandonment. A very important provision in Senate Bill 150. We do not believe there is any similar provision like this paragraph in any of the other bills that have been filed so far this session, other bills in the House and the Senate on this overall topic. And then finally, nothing in this section that we've read so far shall prohibit a school district or personnel from seeking emergency medical services for a student. Quickly moving on now, we are already almost at the end of the bill. This section is amending a statute that already exists. Almost everything you see on your screen that is not in bold and underlined is a statute that is already on the books dealing with curriculum about human sexuality. Senate Bill 150 would go under that existing law and add several provisions dealing with this type of curriculum and instruction. You see there it says, if this passed, it would say any course, curriculum, or program offered in public schools on the subject of human sexuality provided by school personnel or a third party shall fall in several parameters. It shall allow for the parents of the student to decline their student's participation in that course, curriculum, or program and have an alternative course or program provided. That is not too unlike what we already have for similar situations, especially in things such as religious freedom. I know if any program is tied to religion in any way or certain parties or celebrations, there are some religions, for example, where the adherents do not celebrate holidays. And currently, for many years, decades at least, parents in Kentucky public schools, of course, have been able to opt their students out of those sorts of things in the schools and have other programming provided. Human sexuality curriculum and programs, you can see there would be subject to inspection by parents and participating students to allow them to see all these things: the curriculum, materials, lessons plans, surveys, questionnaires. These programs would have to, as you can see at the top, be developmentally appropriate and be limited to a curriculum that has been subject to the reasonable review and response period in conformity with KRS 160.345. That statute was amended just last session in Senate Bill 1 from last year, which changed who and how we adopt curriculum in public schools and created a public stakeholder review and response period for curriculum in general on all topics. And that is what is referred to there. A public school offering any course on human sexuality shall provide notification to parents at least 2 weeks prior to their planned participation. That notification shall contain this information, very similar to the FERPA notification about the federal FERPA information rights for parents. This would inform parents of the provisions of this law, provide the date that the course was scheduled to begin, detail the process for the parent to review the materials we just discussed and listed out, explain the process for them to basically opt out their student in the course, and so on. And then we're at the very end. It closes out by saying that nothing in this section that we've been talking about, the part specifically about the human sexuality programs and curriculum, nothing in this section of the bill shall prohibit school personnel from doing these two things: discussing human sexuality, including the sexuality of any historic person, group, or public figure, where that discussion provides necessary context in relation to the topic of instruction from the curriculum approved pursuant to the process we just discussed, the general process for all curriculum. Or nothing would prohibit the school personnel from responding to a question from a student during class regarding human sexuality as it relates to the topic of instruction, again, as part of the approved curriculum.